We now turn to the last case on today's docket. That is case number 111735 in the matter of William E. Colvin.
May it please the Court, Deborah Hughes, Deputy Disciplinary Administrator, on behalf of the Disciplinary Administrator's Office. I would like to request 3 minutes for rebuttal, please.
3 minutes is granted.
This is an uncontested disciplinary action. The only issue is the appropriate discipline in this case. The facts are set out in detail in the hearing panel's report and also the Court of Appeals opinion that's underlying the initial complaint that was filed with the Disciplinary Administrator's Office. The Court of Appeals opinion found that the respondent's appeal of certain motions that he had filed in a divorce case, a post-divorce action, were frivolous as the basis for the disciplinary complaint that was filed in this case. Before the hearing panel, the respondent stipulated to all of the factual allegations. He stipulated that his conduct in attempting to collect money on behalf of his client that was awarded to her in a divorce decree about 10 years earlier had violated the Kansas Rules of Professional Conduct. And the panel accepted the respondent's stipulations and concluded that he committed the following rule violations. That's KRPC 3.1, which requires an attorney to refrain from filing frivolous pleadings. 3.3A1, which requires a lawyer to take appropriate remedial action when the lawyer becomes aware that he has previously submitted a false statement of material fact or law to a court. And 8.4C, which regards conduct involving dishonesty, fraud, deceit, and misrepresentation. 8.4D, which is conduct prejudicial to the administration of justice. And 8.4G, conduct that adversely reflects on fitness to practice law. Before the hearing panel on the issue of the appropriate discipline, the respondent and I jointly recommended published censure. The panel, however, recommended a 30-day suspension.
And as I understand their recommendation, they did it because he stipulated to the violation of dishonesty, and they felt almost compelled that they had to do that. Is that?
That's how I read it.
That's how I read it. Just they would perhaps agree with the recommendation, but they basically feel compelled to suspend based upon it being a violation of dishonesty, and he stipulated to it.
That's how I read it, that the panel...
So in this case, accepting responsibility really hurt him in that aspect, I guess.
In that sense, although I question whether had he continued to contest it, based on we had a Court of Appeals opinion and a district court's decision finding this conduct to be frivolous, finding that his conduct was a misrepresentation by material omission, that the result would have been the same rule violations would have been found. Would the panel have reached the same conclusion? And the way I read between the lines in the panel's decision is that it felt that because the misconduct in this case involved dishonesty, it had no choice but to impose a suspension. It couldn't impose anything less than suspension.
In fact, it might have imposed or suggested a lesser suspension than it might have had he continued to deny.
It suggests that possibly, or that the panel believed there's a bright line rule on offenses involving dishonesty.
Yeah, that's the way it reads to me too.
And in the sense that that's the suggestion that the panel found, I disagree. I think that it's been the law for a long time that what's an appropriate discipline in a case like this is an individualized determination. This court has said repeatedly when parties attempt to bring forward a number of cases that say, look, in these past cases, based on these rule violations, the court has imposed this type of discipline. Therefore, I should receive that type of discipline. And the court has found that all of those other cases provide little guidance in the disciplinary context because it has to be based on the specific facts and circumstances of each case, and that's long been the law. The ABA guidelines themselves also provide for an individualized determination by providing a presumptive discipline and then instructing or providing guidance to the court to consider then the various aggravating and mitigating factors that might apply in any particular individual case. And so I would also point out, too, that There are a number of cases, I think I found approximately 7 in just an initial search, of cases involving 3.3 violations, candor to the tribunal, in which this court imposed public censure as a discipline. So to the extent the panel believed that there is a line and anything less than suspension cannot be imposed in a 3.3 violation or 8.4C, which is also a dishonesty-based violation, it's not consistent with what the case law is over the years.
What's your recommendation?
My recommendation today remains the same as it was before the panel, public censure. Nothing's changed from then and now that I'm aware of. I believe in my professional assessment based on the guidelines and the respondent's acceptance of responsibility at the hearing and his stipulations and the remorse he expressed at the hearing panel that public censure is an appropriate discipline. And I don't consider it a slap on the wrist, not that the panel did necessarily, but as I thought about that as a censure or as a discipline, it's pretty severe. I mean, the respondent's name will be in the books, on the shelves, in all libraries, in law libraries across the country forever. His name and this decision would appear on the internet in this court's published opinion if it's published. And that can be Googled by anybody at any time and it will come up. So it is a severe sanction, and it's not just a slap on the wrist. And so that was one of the other considerations that I factored into my recommendation.
Are you asking us then to clarify that it should be an individualized determination and not just when there is a 3.3 and 8.4C violation that results in an automatic suspension? Are you seeking clarification of that?
I am, because the panel appears to have believed that, and so for future guidance to hearing panels in future cases, that would be helpful.
Any further questions? Thank you, counsel.
John Ambrosio on behalf of the respondent. Mr. Chief Justice, Your Honors, may it please the court. I agree that this should end up as a published censure. And what happened here is fairly simple. My client is visited by someone who was badly wronged during the course of her divorce action. She had lost out on $175,000 in property distribution. She had lost out on a portion of the 401k because, not under his control, a quadro was never done 10 years before. So he gets involved in the case and he files these actions. During the course of discovery, during a deposition, he first finds out about these 2 prior attempts to collect the money that was owed to this woman. And there is where my client, the respondent, made his mistake. Immediately, he should have either withdrawn as the lawyer for that client, or he should have advised the court that there were 2 prior attempts to collect, and the application of the motion before the court was wrong. He made that mistake. He was trying to help this client, and every time you do something like that, your professional judgment is hurt, and hurt badly. And that's what happened in this case. Then he appealed it, and the Court of Appeals slammed him, and rightfully so. And we're placed with the situation where I'm representing him. What do? Do we continue to fight this, and then the panel and this court eviscerates him, or we just say, we made a mistake, we're falling on our sword, therefore we should receive a public censure? He's been hurt by this, and when I hear lawyers out in the community say, someone just got a slap on the wrist for a public censure, I want to rip my hair out. A public censure tells everybody, online, it tells everybody in the books, it tells the lawyers, it tells the community that there's something wrong with your conduct. This is not just a slap on the wrist. I don't think there's any discipline that's a slap on the wrist. Even an informal admonition is not a slap on the wrist. For those of us who take our duties seriously, our license seriously. My client made some mistakes during the course of his representation, and he should have made a move to withdraw and should have advised the court that what was in his papers was wrong. Since then, and after the appeal, he's been backing up and apologizing and taking responsibility. He apologized during the hearing. He apologized to the panel. I disagree with the panel that he needs to be slapped with a 30-day suspension. Public censure sends the message to everybody in the legal community what one must do when representing a client, and not to get involved in the psychology and the emotion of the moment when representing that client. I disagree with the panel. I concur with my colleague in the disciplinary administrator's office. There should be a public censure, and I do think we need a bright line rule, or I think there has to be something in the decision that tells the panel members, this is a good panel, they're all good panel, that say, you don't have to do something just because it's an 8.4 violation. That's all I have to say. My client would like to direct some remarks to you. William?
May it please the court.
You got it. Sorry, they yell at me for not being elected. You have to be elected.
My name's William Colvin. I was the attorney for Pam Smith. I took this case in 2009 because I really believe that she had suffered a real injustice in court. She lost almost $225,000 in a divorce, and it wasn't a trial. It was a separation agreement that she entered into with her husband, and the agreement was adopted by the court. I was angered by the outcome of this because it was done by agreement, and I got emotionally involved in the facts rather than remaining a detached advocate. There were problems in the case. I should have seen it, and I'm angry at myself for not using better judgment. I apologize to the court. If I could do it over again, I'd do things much differently. Obviously, I can't. I've been in practice for more than 20 years. I've never been involved in anything like this before, and I have absolutely no intention of ever getting involved or making the same mistakes in the future.
What would you have done differently knowing today what you perhaps should have known then?
I would have filed once I found out about these letters and deposition, which was 30 days after I filed the motion. I would have taken the affidavit that she had given me out of the motion altogether and amended the motion to simply make no mention of any letters. My thought process at the time was, well, we'll take all of that up after discovery is completed and put her on the stand and let her explain herself. But if I had to do over again, I would have stripped all of that out. And knowing what the Court of Appeals has ruled and how the Court of Appeals ruled on this, I would never have appealed the case.
Very well, thank you. Any further presentation from either of you? Any more questions? Thank you both.
If there are no further questions, I'll just wrap up and request that the court adopt the findings and conclusions of the hearing panel and impose published censure as the discipline.
Any questions? Thank you. Thank you all for your arguments this afternoon. The court will take this matter under advisement